So thank you, Justin. We will record this, and thanks, McLean, for allowing us to do that. We will have more people joining us as time gets underway, but I want to welcome everyone to LifeCircle Quarterly Conference Call. And Cameo, you will introduce our speaker today, I understand. So thank you for doing that, and welcome, McLean.
Thank you.
Yeah, thank you. And thank you, McLean, for joining us. So McLean Kerver is joining us today, an attorney here in our state of South Dakota from Rapid City. I know her through the Elder Law Committee with our state bar. She is our chairperson, and I'm just going to say doing a great job kind of guiding this process from the legal perspective, from that training side of it. So we've asked her here today to talk about the pieces of guardianship that we've all had those conversations in the healthcare realm. And so with that, I just want to quickly point out Mary Perrineau and Michelle Snyder. Can you two just wave? They've been instrumental also, along with Luann, in just sort of guiding this process on the LifeCircle end of it. So thank you to each of you. So McLean, if you have questions for us as you go along, or all of those on this conference call, please, don't hesitate to add input, ask questions. And McLean, I'll turn it over to you just to add to that intro. Maybe tell us why you're passionate about the guardianship issue, and then yeah, proceed as you'd like.
Sounds good. Thank you. Well, thank you for this opportunity today. As Cameo said, I am the chair of the Elder Law Committee for the State Bar of South Dakota. I practice in the area of estate planning, guardianship and conservatorship, primarily for the elderly. I will say guardianship and conservatorship can take place for minors, but primarily I'm focused in the elderly area. I do probate and trust administration, so really happening and helping families with processes after death, as well as dealing with some of the issues prior to death. I love this area of law. I wanted to get into a career where I really felt like I could make a difference for people. And you see a lot of stress relief, go from people's bodies when their estate planning is done, or when they finally have a guardianship or conservatorship in place and things are in line and decisions can be made. And so it's very rewarding area of practice for me. And it's a good fit for me because I'm really not or contest, and this is really kind of a feel-good area of law, and I really enjoy it and I'm passionate about it. So I'm going to try and share my screen. I will say if I have any troubles, Cameo has agreed to help me out in that realm, and we'll see how it goes. I have prepared a PowerPoint presentation. This is in no way intended to be solely a presentation to you all. It's to guide us along our path in this meeting today. So if you have questions, please ask them, unmute yourself and ask them, interrupt me, because the goal of this meeting today is for me to provide you information that maybe you're missing or don't know about, or how do we get you access to that information. Cameo and I were talking before this. She is also a member of the Elder Law Committee. And if there's anything that we don't know, we certainly can go do the research. We can go back to the Elder Law Committee, and we're happy to get you guys that information. So with that, I'm going to share my screen here. So give me just a second. Cameo, can you see my screen?
Not yet.
Okay.
Nice. It's up, or it's coming up. Yeah.
Good?
Yep.
Okay, great. So that I have to provide this. This isn't intended to be legal advice, but this is our general disclaimer. It's not to substitute legal advice, but it's just here for general information. Okay, so I know that the individuals on this conference call today generally deal in the healthcare area, and I'm sure a lot of you are familiar with a lot of these terms, but I wanted to start from the beginning just so that you had a general idea of certain terms as I'm talking about things. Generally, when we talk about guardianship in South Dakota is related to the body of somebody, making healthcare decisions, personal care decisions for someone. So a guardian is somebody that's appointed by the court to be responsible for those personal affairs of a minor or protected person within that definition. I also wanted to provide you with the definition of what a conservator is, because the conservator is generally the one paying medical bills, all of that sort of thing for the protected person. So a conservator is a person appointed by the court to be responsible for managing the estate, the assets, the financial affairs of the minor or protected person. These people could be the same person. I could be a guardian and conservator for someone, or I could be the guardian making healthcare choices. Somebody else could be appointed as the conservator to make financial choices for somebody. There may be scenarios too where just a guardian is appointed by the court and the court does not see a need for a conservator, or vice versa. A protected person or a person alleged to need protection is somebody for whom a guardianship or conservatorship is going to take place. So a guardian or conservator has been appointed. So when they are deemed a protected person, a guardian or conservator has been appointed for them. When they are a person alleged to need protection, we are starting the guardianship or conservatorship process, and that is the person that potentially needs protection. A little note at the bottom, which I said at the beginning of this presentation, is that guardians and conservators can be appointed for minors, but that's really beyond the scope of this presentation. I will also mention that I speak relatively quickly. So if there is anything you didn't catch and you need me to go back a slide or stop me, just holler out and I will do so as we go forward. One of the first things I think that you need to know in the guardianship process is really who can serve as a guardian. So again, I mentioned conservators, but I'm going to focus primarily on a guardian in this case related to the healthcare decisions for a protected person. Any adult can really serve as a guardian so long as they're not employed by a public agency, entity, or facility that is providing substantial services or financial assistance to that person. A public agency or nonprofit corporation, with those same exceptions, can serve. If there's no other individual or entity, the Department of Human Services or the Department of Social Services can be appointed. And it is important to note that no creditor of a protected person can serve as somebody's guardian. A bank or trust company could come in and serve as somebody's conservator, but they generally will not serve as somebody's guardian. And we'll talk a little bit about who's available to be guardians kind of at the end of this presentation, because there is kind of this quasi entity, and I'm not sure that there is one similar to it in Sioux Falls or anywhere else in the state, but in Rapid City, and they do serve across the state. And Cameo and I have talked about this entity, and I'm not necessarily promoting them, but you need to know that they're out there. Is Black Hills Advocates, and they do serve as guardians for people, but they are actually a for-profit entity, and so we'll kind of talk about that near the end of this presentation. So requirements for being prior to being appointed. South Dakota adopted our Guardianship and Conservatorship Act back in 1995, and it's a uniform act, which means that the Uniform Laws Commission worked really hard to create an act that hopefully their goal was, if all 50 states adopted it, then we would have these uniform laws across our country. And almost all the states adopted the Guardianship Conservatorship Act, but not all of them. We have also made some changes since 1995, which are not necessarily part of the original Uniform Act. And it is my understanding that the Uniform Laws Commission has updated their Guardianship and Conservatorship Act to provide maybe more flexibility to an individual who needs to have a guardianship and conservatorship, with maybe more kind of protective orders rather than a complete guardianship conservatorship. The Elder Law Committee has started a review of that several years ago because one of the legislature was considering, senator I think was considering putting forth that legislation, but it never was. So we really haven't had a chance to, or had a need to really look over that Uniform Act because it hasn't been put up for vote in our state at all. But what our state has done is our Chief Justice has come in and he had an elder abuse task force appointed. They really looked at elder abuse, protecting the elderly. So some of our statutes on powers of attorney, some of the statutes within the guardianship realm were updated to try to provide some more protection within this realm, because guardianship can be a really beneficial thing for individuals who are incapacitated and can't make these decisions, but it can also be very ripe for elder abuse. So there's kind of this fine line, and I don't think anyone would agree that our statutes are absolutely perfect, but they're trying to do their best to balance elder abuse with the ability and understanding that for some people there needs to be somebody making choices for them. So with that, background checks are now required and they need to be completed prior to somebody being appointed a guardian for somebody, unless the court deems for good cause shown that this might need to be waived. And we'll talk about that a little bit here, primarily for temporary appointments at the end of the slide. But completion of training curricula also needs to be completed before you are appointed, and that can also be waived by the court. That training curricula is provided by the State Bar of South Dakota, the Elder Law Committee, and the Real Property Trust and Probate Committee of the State Bar, and some other various members, along with several judges, were on this committee to initially create the training, which I will admit was done with relatively fast and low notice speed to begin with. And then after some updates this year, the training really, the Elder Law Committee took a lot of time and commitment to try to make the training better and easier for people seeking guardianship or conservatorship. And that training is available on the State Bar's website. So you go to the main page, you can click guardianship and conservatorship. It sets forth training. It gives some links to various things that a guardian and conservator might need to know and how to do certain things as well. So I'm going to start with the appointment process. Again, if there are any questions, please jump in. But the first thing that you need to do in order to have a guardian appointed is a petition needs to be filed before a court. And I guess I'll take a step back, which I kind of discussed at the end of the presentation too, but powers of attorney can supersede an appointment of guardian and conservator. So if somebody has a healthcare power of attorney, there may not need to be an appointment of a guardian. So those documents, as I'm sure you all know, are very important in planning ahead for somebody's potential disability, incapacity, that sort of thing. A guardian, though, once a guardian is appointed, can override that power of attorney, meaning that the healthcare power of attorney is no longer valid for purposes of that person making decisions for somebody. It is now the guardian that makes those decisions. However, our statute set forth that if the protected person had a power of attorney and a guardian is appointed, the guardian is supposed to follow that person's wishes with regard to end of life care and that sort of thing. So filing a petition really happens when there's no healthcare power of attorney in place, or when somebody's fighting, two healthcare powers of attorney have been presented. We don't know which one is valid or which one controls. And so ultimately somebody says we need a guardian appointed, the court needs to make this choice, and then the guardian would make those decisions. So in order to get a guardian appointed, a petition needs to be filed. these are the people that can file a petition. So the person alleged to need protection can actually file their own petition if they can, want to, that sort of thing. Any interested relative can file a petition. An individual or the facility caring for that individual, which could be hospital, nursing home, assisted living, rehab, that sort of thing, could file for guardianship if need be. Any individual or entity nominated to serve by the alleged protected person. So generally in a healthcare power of attorney, we will put in provisions saying if a guardian needs to be appointed, I nominate either my agent or so-and-so to serve as my guardian. And so those people can file a petition, and any other interested person or entity can file a petition. So really it's pretty broad. If there is a need, a petition can be filed, and this covers most of who would do the filing. You can file a petition without an attorney. There are forms, which I've got a link at the end of this presentation, to guardianship forms. The UJS or Supreme Court has links to pro se guardianship forms. Pro se means you don't have an attorney, and ultimately you're going to be doing it on your own without an attorney. So there are some links to some forms through the Supreme Court website. But generally it's recommended that an attorney be help you through this process, or anybody through this process, just because it tends to go relatively smoothly. Attorneys do this all the time, that sort of thing. But it's not absolutely necessary. And sometimes we come in to help with the appointment, and then the guardian says, hey, I can handle filing the annual reports and other requirements, and we step away and they take control of it on their own. So that can happen as well. But when you're filing a petition, you need to know what kind of guardianship you are requesting from the court. And there are generally three types. One is a temporary, which is what I mentioned earlier. And temporary is there when there's a show of immediate need. Absolutely necessary. We've got something happening. That could be the individual needs a decision on, life-sustaining treatment now. The individual needs it, that, they're in the middle of a closing on a house sale and they have a embolism or something like that, to where they're now incapable of making decisions. We've got somebody who's isolating themselves, not eating. We've got somebody who maybe is being abused, and not necessarily physically, but financially, that sort of thing. Those are immediate need, temporary guardianship reasons generally that the court will appoint a temporary guardian. It could also mean we need placement fast. We're in the hospital and now we need to get them placed. You could do a temporary guardianship for those reasons as well. The temporary appointment lasts for a maximum of 90 days, so around 3 months. If there is a need for it to be extended, it can be extended for an additional 90 days, but then after that period, so basically after 6 months, we either need to tell the court that no guardianship is needed any further, or we need to petition for a full guardianship. So the temporary guardianship, like I mentioned before, is for immediate need. And generally a court will waive the requirement of background checks and training if we need to appoint somebody relatively quickly. But it's always recommended that you start that process, even though the background check may not be complete by the time you're appointed, or you may not have started the training by the time you're appointed, but we recommend you start the training. It just shows, for whoever's being appointed guardian, it just shows goodwill to the court, and you will need that stuff if we're going to reach a full or permanent guardianship. Limited guardianship can last the lifetime of an individual, for example, or for so long as it's needed. But a limited guardianship really is there for the court to say, this person really doesn't need a full guardianship, but they need somebody to help them through a property sale, or they need somebody to, make decisions with them on, maybe help them with some estate planning stuff, but they really can make their own end of life care decisions, right? So it's limited as to what the protected person needs help with, and the court sets forth the powers of the guardian in the letters or the court order. And the letters of guardianship are what are presented to the hospital, to the clinic, to show that somebody has the ability to do certain things for an individual as a guardian. A full guardianship gives the guardian all the powers allowed of a guardian under South Dakota law, all the powers really of that person to help that protected person with decisions that really need to be made. Full and limited guardianships, like I said, can last the lifetime of an individual if that is what is necessary. Or if this individual, let's say, has a traumatic brain injury and we need to appoint a guardian for them to make healthcare decisions, but then there is a recovery to where this individual recovers and can then make healthcare decisions for themselves and that sort of thing. And really, the doctor says the guardian really is no longer needed because this person is doing fine and making these healthcare decisions, doing personal care decisions. You certainly can terminate a guardianship upon recovery type thing. And anyway, so limited guardian can last a lifetime or for a period of time that it is ultimately needed. But temporary really is for that emergent need. We've got to do this quick. I need the court to waive some requirements so that I can get this done. But then you're going to ultimately come back and petition for limited or full guardianship after that point. One of the requirements for filing a petition is that we have to include an evaluation report of the person alleged to need protection when we're filing a petition. So I will start with this in general. This requirement is under statute, and it generally applies to when you're filing a petition for a full or limited guardianship. And we'll talk a little bit about temporary. But generally, the petition includes an evaluation report which outlines the condition of the person. The report must describe the nature of the incompetency, evaluate the medical, physical condition, mental condition of the person, describe services that are currently being provided to the person, and recommend the most suitable program. The evaluation report should outline the current medications being taken by such person. It should provide an opinion regarding the necessity of the appointment for a guardianship or conservatorship. It should state whether the person alleged to need protection can attend the hearing, and provide assessment dates to which the doctor relied upon in order to come to these opinions. And our evaluation reports in our statutes require that the report must be signed by a physician, psychiatrist, or licensed psychologist. This doesn't mean that a nurse practitioner, other sort of individual can help fill out this report. And those individuals also need to sign the report if they do, but the statute does require that in addition to that person who's filling out the report signing the document, that it be signed by the physician, psychiatrist, or licensed psychologist. So in temporary guardianships, or in other cases, full and limited, there can be reasons that it's not possible to get the evaluation report prior to the filing of the petition for guardianship. That can be for example, in a temporary, it could be that we need an emergent need and it's really hard to get a full evaluation report like that done in time in order to help this person. It can be because of HIPAA. It can be because it's going to take a little bit to get into the doctor to get the evaluation done. It could be that the doctor's on vacation, whatever the scenario, right? There just can be a delay in getting the evaluation report. We have statutes that say we can ask the court for leave to file the petition without the evaluation report. But if we do that, the court needs to order that an evaluation report be done. So they order the appropriate assessment or examination and that the report be ultimately prepared. The evaluation report is a sealed document, so it is never provided to the public. The public can see that an evaluation report was filed, but they can't see the actual evaluation report. in a temporary guardianship situation, a lot of times what we will ask for from physicians, medical staff, that sort of thing, is some sort of note, letter from the doctor, that sort of thing that says this person is unable to make personal, financial, healthcare decisions for themselves. They need assistance in doing so. Maybe just a short letter saying, you know, they've been in an auto accident. Here's what's happening. They're in a coma. They cannot make decisions for themselves, just so that we can submit something easy, quick and easy to the court, but provide the court accurate information as to why we're seeking this immediate need. If it is for somebody that's isolating, not eating, that sort of scenario, and there still is an immediate need, most of the time what we submit is an affidavit from individuals who have seen that individual, maybe some pictures setting forth this person and that their current state, especially if they're a hoarder, for example, and it's really affecting their livelihood. And then again, some note from the doctor saying that this is a problem and we need somebody appointed now. Any questions so far?
I have a few, McLean, but I think they'll fit nicely into the end as well, because you're kind of on a nice roll of just going through the process. If anyone else has some, jump in, but.
Okay, great. Thank you. Okay, so you find somebody who needs or you have somebody that needs a guardian appointed for them. You have somebody that can serve as a guardian and is willing and able to file a petition, and they either meet the requirements or it's determined that we need to have a temporary guardian appointed for them. The next step after you file a petition is the hearing. You are required to have a hearing. So if we're seeking full or limited guardianship, I'm not talking about temporary at this point, but if this is just somebody who we've recognized maybe has dementia, which I understand is a disease that can have varying lucid periods, or we've got Alzheimer's or something, a progressive disease that we're now recognizing guardianship is necessary for, and there's no immediate need, for example. You file your petition. So the person seeking guardianship files their petition, and then a hearing must be held within 60 days of the filing. So that means that a hearing might not be held for 2 months from the date of the filing of the petition. That's why you kind of need to assess, and if doctors are involved saying we have immediate need, that needs to be communicated to the attorney or the person seeking guardianship, because this process can take a bit of time. So if the evaluation report could take longer than 2 months to obtain, the court can extend when that initial hearing needs to be held another 60 days. So again, we could file a petition for guardianship, and that initial hearing might not be held for 4 months, for up to 4 months. I also am required, so when I file a petition for guardianship, I'm required to give the person alleged to need protection and everyone else at least 14 days notice of that hearing. So you are looking at a timeline for a hearing of, I file my petition, and at least I have to give you or the interested parties at least 2 weeks to get the petition, read it, potentially get an attorney, whatever the scenario is. They get 2 weeks notice, so I can't have a hearing for at least 2 weeks, or up to 2 to 4 months. So again, if there's an immediate need, temporary needs to be sought rather than the general full guardianship. The person alleged to need protection must, and this is in our statute, must attend the hearing, which is why the evaluation report asks the doctor to say, can they attend the hearing or not? And I've had some physicians say physically, sure, they could attend the hearing, but this will mentally break them if they attend this hearing, right? Because of their mental state. They can't handle this, and this will really upset them and set them back. So no, I'm not going to recommend that they attend the hearing. I've had doctors say, yes, they can attend the hearing, or no, they physically can't attend the hearing, or, we're in a coma, they can't attend the hearing, that sort of thing. But because of this requirement that the protected person or person alleged to be in need of protection has to attend the hearing, that's why that's in the evaluation report. The alternative, so if the physician says they cannot attend the hearing, then the alternative is that our statutes require that an attorney be appointed for this person, or that a court representative be appointed to go meet with, assess the protected person, and then come back and report to the court. The reason these requirements are there is because guardianship and conservatorship is the removal of substantial rights for these individuals. And it is important that the court hear, if the individual is able to communicate, that yes, they want this person appointed, no, they don't, here are the reasons why, they're struggling with this. They have a right to have a voice at these hearings, and not just have somebody come in like a bull in a china closet and ultimately take away all of their rights. I have represented several protected people, and they have stated things to me like, there's little green men in my dishwasher, right? Or whatever. And I am still required to present that to the court as their reasonings for either why they do or do not want a guardian appointed. And the court then gets to assess, whether this person, given their evaluation report, given their statements, that sort of thing, that a guardian and conservator should be appointed for them. So even if those statements by that person that's alleged to need protection, or the protected person, may seem not medically sound or not reasonable or coherent, they still have an absolute right to have a voice at these hearings, and the judge is going to want to see those statements, those reports, know that somebody has at least tried to talk to them. If they're in a coma and can't speak, that somebody went and talked to their family members, and gave some sort of report to the court to represent this individual. So that's why they're entitled to notice as well, and all of that sort of stuff. For temporary appointments, normally there is no hearing. So again, if there is an immediate need, somebody needs something now, quickly, fast, we've got an emergency, what we do is we get all of our ducks in a row for our petition, ask for the court to waive background checks, evaluation reports, try to submit a letter from the doctor showing what the immediate need is, and then we email or run to the courthouse with an order, meet with a judge. If the judge agrees there's immediate need, the judge signs the order and we file it and somebody's appointed. This is what we call obtained ex parte. It means that we went to the judge on our own without giving anybody else notice, including the protected person, and got somebody appointed right away. Generally, the requirement after a hearing is that you send notice of that appointment at least 5 days after the appointment, and that a hearing be set in the future so that everybody can come in with objections and that sort of thing, but there is at least somebody there ready to make decisions. No, so I kind of went into this, but notice for appointment on a full or limited guardianship. So when we are not in an emergent need and somebody is appointed guardian for somebody, that person must send out a notice saying they've been appointed, along with a statement and the rights of a protected person, to set forth that somebody's been appointed their guardian, but you do have the right to seek termination if you don't believe this is right, to seek modification if the protected person says, no, I can make my personal care decisions, but I need some help with, I use estate planning in this scenario, but that's really not the guardianship realm. But there are certain things that they may be able to do, and they could seek modification of that guardianship. That notice for a normal, full, or limited guardianship has to be mailed out within 14 days of that appointment, whereas temporary guardianships, like I mentioned earlier, need to be mailed out within 5 days of that appointment. So it's also important for everybody to understand the effect of appointment of a guardian. And I mentioned earlier that this is the potentially the taking away of substantial rights of an individual, which is why the protected person has rights throughout this process. Just because though that a guardian or a conservator has been appointed for somebody does not automatically mean that that protected person has been found to be legally incompetent. And so what that, unless the court makes a finding of that in the guardianship or conservatorship or orders otherwise. And what that generally means in our guardianship and conservatorship statutes set forth what a guardian is supposed to do. You know, it discusses the financial obligations, the personal care obligations, but it also reiterates over and over and over again that the guardian and the conservator is supposed to communicate directly with the protected person, try to understand and assess what they want for their personal care, for their housing, you know, for their finances, that sort of thing, and then make choices in that person's best interest. And it may be, okay, you want assisted living rather than nursing home. Is that feasible for you? Let me talk with your doctor. Yes, that's feasible. Great. We'll try to get that worked out. And it may not be feasible. And the best interest of the person may be nursing care or some other sort of care, even though the protected person doesn't want that. So they're to look at the person's best interest, but at the same time, they're supposed to take into account what that protected person wants, needs, has stated desires on, that sort of thing, especially with end of life care. And like I mentioned, powers of attorney will and can govern, because the guardian is supposed to look at the protected person's wishes for medical and end of life care, even though that power of attorney is no longer valid for purposes of appointing somebody to make decisions for somebody. So there are additional resources, and what Cameo and I had kind of talked about is, you know, where are forms located, what other resources are there available for guardians, that sort of thing. So the State Bar website, if you click the Guardianship and Conservatorship tab, has additional resources, instructions. It gives instructions for background checks. It gives the link to the UJS forms. It talks about how we have electronic filing in South Dakota. So it talks about, there's an access guide on how to access our electronic filing, how to file electronically if you're not an attorney. It gives a link to Adult Services and Aging, which is DSS website. It discusses frequently asked questions. It's the one that provides, the State Bar is the one that provides the training. It provides a guardianship and conservatorship appointment checklist. It provides conservatorship forms. It gives the annual report forms. It gives the annual accounting forms for conservators. We have a form for the evaluation report for the doctor, so they can just simply hand you a form to complete. It gives forms for, you know, obtaining, like I said, the background checks. It gives a link directly to our statutes with regard to guardian and conservator, and it also gives a link to a vulnerable adult protection order forms. Part of what the Chief Justice in, I think it's 2016, enacted the task force on elder abuse, and they updated some of the criminal statutes that make it felonies for elder abuse, financial exploitation, that sort of thing. They also updated the temporary restraining orders if there is somebody, so there now is an elder abuse temporary restraining order for somebody, which is what this vulnerable adult protection order is about. And so this is a great place to go for access to other information, providing people access if they're requesting it from you. One of the questions Cameo said that you all might have is, how do you find a guardian? And I assume this question was more, how do you find somebody to serve as a guardian, rather than how do you find somebody who's court appointed already as a guardian? So court, if it is, how do you find somebody who's already court appointed? They should have already supplied you with their letters of guardianship showing that they've been court appointed, that they have the power to act on this person, and it should be in their file. Or they should be providing it to you if they've made some sort of statement. If you have an individual that you think, oh, this person really cannot make decisions and we need to find somebody to help them, normally you look to the persons, if they have a power of attorney, to somebody named in their power of attorney, right? To the family members that are at the hospital, at the clinic with this person to start the conversation with regard to that. If this person doesn't have family or friends with them, if they don't have a power of attorney that nominates a guardian, or if they don't have a power of attorney that can make healthcare decisions for them, there are several entities that will serve in this role potentially. One of them is the South Dakota Guardianship Program. They're based out of Pierre through the Department of Social Services. And there are some community organizations, and one of these is, like I talked about, is Black Hills Advocates. Both of these entities fill a role for basically elder orphans, is probably a good way to describe it, where there really is nobody there to help make these choices for them. The difference between the South Dakota Guardianship Program and Black Hills Advocate is South Dakota Guardianship Program is a nonprofit, where Black Hills Advocate is a for-profit entity. But both of those entities are required to do background checks. They're required to do the training, and they really come in to fill, there's kind of a gap in this area. I do know, that some hospitals, clinics, that sort of thing have the ability to, there's some finances maybe available for helping someone help be that guardian for that person. And so in those situations, this may be, the hospital or something may be calling Black Hills Advocate to say, we need help. This person really doesn't have anybody, and we've got some funds available to help pay for this type thing. I do know that I'm trying to think of other, South Dakota Guardianship Program is nonprofit, and so they do have funds available to help, or at least DSS has funds available to help somebody get appointed, so an individual get appointed. So I think it's maybe like $500 or something towards attorney's fees to get somebody appointed. So maybe the South Dakota Guardianship Program isn't actually serving as the guardian, but there's some funds, even though minimal, available to help get an individual appointed if you find a family member that maybe can serve, but that there's not a lot of money here. I will say that the guardianship process can be expensive, as you all know, because most of those, the actual process through the court is not expensive, but the expense comes with the attorney's fees and that sort of thing. Attorney's fees for guardians are paid with the protected person's assets. So generally the person serving as guardian does not pay those attorney's fees. They're paid by the individual that needs protection. They're court approved. So is the attorney that's appointed on behalf of the protected person. Those attorney's fees are paid by the protected person's assets. So you can see that if you get two attorneys, one for the guardian, one for the protected person, it can get rather pricey. So how do you reduce that? Really, one of the best cost savings is not going through the guardianship and conservatorship process, which means powers of attorney are in place before somebody gets incapacitated or is in this emergent need. Because then it's an attorney spending an hour drafting a power of attorney, or somebody, the hospital, providing their free powers of attorney to an individual, and then there's somebody in place when that emergency happens. There was one question that Cameo and I talked about as to whether attorneys will serve as guardians. And I say generally not. I guess there could be attorneys out there that do serve in that role, but ethically, I do not believe that we can. Part of that reason is because we would then be putting ourselves in a role to where we could receive a fee, because guardians and conservators are entitled to receive reasonable compensation for serving in this role. And ethically, I do not serve in that role. I do not believe my malpractice insurance covers that role. And so I do not serve in that role. And most attorneys that I know do not serve in that role. I would rather serve as the attorney guiding the person seeking guardianship, as opposed to actually serving as the guardian. And as I mentioned before, banks, trust companies, that sort of thing, generally don't serve as guardians. They would rather serve in the conservator or financial realm. Like I talked about, the guardianship process is for somebody who is already unable to make their own choices generally. And so powers of attorney are very important if you're talking about how do we plan for this so that these immediate needs don't happen. The Guardianship Act is there to allow immediate appointment through the temporary process. But really, if somebody's already at the appointment of, I need a guardianship, but it's not necessarily immediate, you're too late for planning ahead. That planning ahead needs to happen at maybe the beginning of the diagnosis of dementia, if not even before, as soon as somebody turns age 18, because accidents can happen to anyone. And as soon as you're 18, you become an adult. When you are a minor, your parent acts as your natural guardian or conservator. But as soon as you're age 18, really the process should be talked about at that early of an age, especially if you got, well, I mean, an auto accident can happen anywhere, but if you got kids going away to college and they're driving long ways, it's just a good conversation to have starting at age 18. And like I said, the powers of attorney and living wills are the best way to at least have a decision maker for the healthcare powers of attorney. And I'm sure, as all of you know, healthcare powers of attorney and living wills can be separate documents. So for somebody who maybe is in what we call an elder orphan, they may not have somebody that they can name or that they trust to name, or that they don't want to put that burden on to make those healthcare decisions for them. At the very least, they should have a living will which directs they either do or do not want life-sustaining treatment, whether they want a DNR, all of that sort of thing. So really, those are the kind of the start of the process happens with it. Should happen early in life, talking about powers of attorney. Some of the questions that, again, Cameo and I talked about is, is there a way to make the guardianship and conservatorship process easier, cheaper, better? In my opinion, the challenge with this question is that the guardianship process is trying to encompass a lot of scenarios, and not just that scenario of, now here's an individual that got in an auto accident and we need somebody appointed because they're in a coma. Or, here's the individual that waited too long or didn't want to make these choices, so now they're left to somebody else. So that's one of the scenarios of guardianship conservatorship. The other scenario really is, like I talked about, powers of attorney should be talked about to somebody who's over the age of 18 or 18 or older. Guardianship can be, and a lot of times is, for those individuals that have capacity but need some help. So I've had protected people that really wouldn't be deemed incapacitated, but they're struggling and they agree that they want a guardian appointed and they want to go through the guardianship process. So as things get worse, this person's already in place. And we've gone through that, and they agreed to the appointment, and they showed up at the hearing and said, yes, I want this. I want to be able to make decisions up until a point I can't. But then when I really can't, I want this person already in place and ready to go. It's also for disabled adult children, basically. DAC is a designation with DSS, but for those individuals that were disabled or deemed disabled, whether that's physical, mental, whatever the scenario is, from the time that they are children and will be their entire lifetime. We seek guardianship and conservatorship over them after they reach the age of 18 because they are deemed adults. And so it's not this emergent need that sort of thing. So I struggle with answering that question because guardianship is, the act is really trying to account for multiple scenarios and not just a couple, if that makes sense. And like I said before, this process takes away an individual's rights and gives those rights to someone else. And so not only is the court going to look to protect this person, but they are going to also, this process. So somebody comes and says there's immediate need, we need to appoint somebody, and we're asking the court to waive background checks, to waive training, because they have this note from the doctor that it potentially is ripe for abuse. I mean, there are people that thrive off of elders that don't have anyone, and they financially exploit them in order to inherit their property, to steal their property, to get control of them and keep them locked in their house in order to have a place to live. I mean, you all have seen this and we have seen this. So I don't think our act has necessarily addressed all these scenarios, but it's trying. The court system is trying to make sure that we hold these people accountable, give the protected person enough time to say, whoa, if they can, don't do this because I can make these choices, or maybe I need some help, but not by this person, or not to the full extent that this person is applying for guardianship. So, and why is it so expensive? And the reason is because attorneys are coming in trying to do a lot very quickly. So if you have to do, specifically in temporary, if we have to seek temporary guardianship, we have to file a petition for temporary guardianship, at least get a note from the doctor, ask for all of these waivers, run to the courthouse, get an order, file our notice, start getting things in place to get decisions made. So somebody's making decisions, and then we've either got to file another petition to extend the temporary, or we've got to file another petition to appoint now a permanent guardian because this isn't going to be cured, or this person isn't going to be able to come out of this. And so really we're doing double duty when you start with a temporary. So if there's an ability to wait, that's great, but a lot of times there's not. I will say in South Dakota, access to our courts is incredible. We are a small state. Our bar is very small. A lot of attorneys have the ability, and the judges are open to us emailing them to saying, hey, we've got an emergency. Can you help us with this? The clerks are great at telling us who's at the courthouse and available so that we can talk directly to that judge rather than getting assigned a judge that may be on vacation and having to wait for that judge to be assigned. So with that regard, South Dakota is amazing, and we probably can get things done a lot quicker than, say, California, New York, where it's really hard to access the court system in this scenario. But as you all know, and the reason you're here, the best way to prevent all of this and the expense is to make sure that those healthcare powers of attorney are in place before these scenarios even come up, because it really is the only way to avoid this process. So really that's all I had. Cameo, I guess I'll let you direct me on what questions we have, and I'll try to stop sharing my screen here in just a minute.
Yeah, thanks so much, McLean. I appreciate that. One quick question: when you're talking about limited guardianship and then even temporary guardianship, and I'll let others speak to this, but it seems like one of the big questions is there a limitation on the decisions that guardians can make in end of life care? So, maybe a DNR order is in the best interest of the patient. Can a limited guardian or even a temporary guardian authorize that?
So yes, generally the limited, I want to start with the limited. So the limited guardianship is there expecting it to go on for a longer period of time than 90 days. Okay. But the limited guardianship is limited by the court assessing the individual and saying, these are the capabilities of the individual. So guardian, you only have the power to act on this individual's behalf with regard to, and then fill in the blank, right? So it may be end of life care. It may be where this person is going to stay and reside, but it's limited and set forth in the court's order and the letters. So if the letters say this person can, designate a DNR, can talk about end of life care for a limited guardian, yes, that person can make those choices. For a full guardianship, the guardian has all of the powers to make all personal end of life care for those individuals. One of the processes that I have gone through, because our statutes don't necessarily directly address DNR. And so because of that, we have petitioned the court to the guardian, and the protected person indicated they wanted a DNR, and it had indicated that that's what they wanted, but couldn't really make their own decisions. So the guardian petitioned the court to get court approval to have a DNR on this individual. So we certainly can go through that process so that it's there's a backup for a guardian if they ever got flack, or if the doctor said, I really need documentation, there's a court order authorizing that sort of thing. Conservators, I mentioned estate planning. Conservators are really the one that would go in and ask the court for changes to a person's estate plan, and that could include powers of attorney being executed on this person's behalf, DNRs, changes to wills and trusts, and that sort of thing. But it does require a court order to change some of those documents.
So would it be fair to say that full guardianship gives, full power,
Right.
Limited, if it's just limited to healthcare decisions would include DNR if the healthcare team thought that that was in their best interest, if the guardian did.
Right.
Okay.
And generally the court, I have very rarely had to enter into a limited guardianship, right? But if it says limited guardian, if that's what the letters say, then the letters in the order need to expressly state what those powers that that person has. So the doctor should be able to see if they have healthcare decision-making capacity, or if it's specifically limited even further than that.
Thank you. Anyone else have questions or a scenario maybe for McLean? Just remember, she made it through law school, so the more complex your scenario, the better. If not, maybe I'll give you one. What if we have a homeless person and care can't move forward, and there is no one identified, but it's very obvious they need a guardian. That temporary guardianship is probably the best process, but maybe even not fast enough. What are your thoughts on that? Is there a solution?
So is the homeless person incapacitated to where they can't sign a healthcare power of attorney?
Let's say yes.
Okay. That's a real struggle, but I would say, I'm looking, Barb Vargo is in the room with me, but we could probably get a guardian appointed within, if we got all the documents in a row, within 3 days, right? So I don't know, that's fairly quick. If it is, there's not really much of a option for somebody who doesn't have family member. You're looking for somebody, you're looking then at calling the South Dakota Guardianship Program, DSS, you're looking, or Health and Human Services, you're looking at calling somebody like Black Hills Advocate or some other entity like that, seeing if they're able to serve, to then get them appointed through the temporary process. Otherwise, you really don't have a lot of options other than keeping them comfortable and working through that scenario. There was one, I think, cameo that I wanted to look at that I did put in my PowerPoint, but that we kind of talked about, was a question about the best ways to have healthcare goals of care conversations. I will say Cameo was part of the elder law committee subcommittee that was when we put together the guardianship conservatorship training. And the issue, she raised a lot of issues about how do we have care conversations with individuals. And there's not really a good answer to this, but it's probably worth looking into. And I don't know which way it goes, but the bar and the legal process for getting a guardianship appointed is there. The mindset is, okay, we've got to legally have somebody stand in the shoes of this person who needs protection, right? So how do we do that? And what's the process for doing that, whether it's relatively quickly or through the normal notice standpoint? So the training that the state bar provides does provide some of that. Communicate with the doctor on care. You're responsible for communicating with the protected person, understanding their rights, that sort of thing. But I do think there is a strong need, because a lot of times guardians come into this saying, yes, I'll serve because I love this person. But they're not medical doctors. They're not lawyers. They don't know what a DNR is. They don't know what end of life care looks like, because they haven't been through that with anybody in their family before, right? So I don't know if there's I don't know if there's, that's us saying we should increase the curricula through our statutes, saying not only here's training on what you're legally required to do through the court system, but we also need to legally have training on these are the decisions you're going to make and what they mean. I don't know if you see there's kind of a conundrum between the medical field and the decisions that they're going to be making and their legal appointment and the authority that they have. Does that make sense?
It does. And I think this group has been working really hard on healthcare and to kind of fill some of those gaps, if we could call them that. And so maybe further conversations, I know we're at the end of this year time and ours, but that would be great further discussion. I know there's, you mentioned your passion. This group has proven time and again to just be passionate about those same topics. So I'm excited to have that discussion. If you would want to continue with us, maybe, that's a task of Elder Law Committee partnering with LifeCircle. That could be a great step forward.
That'd be great.
Well, thank you so much for joining us. For those who haven't been able to express their questions here or maybe have them afterwards, are they able to contact you?
Oh, sure. Happy to help. Anyway.
Okay.
Yep.
Awesome. All right. Well, thank you so much. Yeah, we appreciate your expertise and future collaboration, whatever that looks like.
Yeah, and I will also say I did send Cameo my PowerPoint. So if anybody wants it, I give her authority to send it to the group or whatever, just for easy reference, because I know sometimes it can be hard to take notes on this stuff, especially when I'm speaking a mile a minute. So feel free to do that, and I'd be happy to answer any questions.
Thank you so much.
You bet. Thank you for the opportunity.
Thanks, everyone.
Thanks.